This matter involves a petition for post-conviction relief that Carlos Key had filed, and that was ultimately dismissed by the trial court without having a hearing on it. Initially, I'd point out that the trial court judges in that division switched. So it started off at one trial court judge and ultimately ended with a different one. Initially, counsel was appointed on February 25th, 2019, to review the claim, represent the petitioner who had filed a pro se petition as well as a memorandum incorporated with the petition that was, I believe, over 20 pages. The state then filed a response February 25th of 2019, acknowledging that there was a colorable claim and acknowledging that it was appropriate to then have the matter set for hearing. On February 28th, 2020, I was ultimately placed on the case, and then ultimately on May 19th, 2023, the case was set to be heard on a hearing. Now, the most relevant law as it relates to the post-conviction statute and the requirements is spelled out in the briefs, as I understand you all have read. But when the facts are placed in the petition and the court concludes that the petition does not include a colorable claim, it may summarily dismiss the petition without appointing counsel. In this case, which is very different, it was reviewed by the trial court. It was determined to have merit. An attorney was appointed. The state responded saying it in fact had merit and needed to have a hearing. And then it was set for a hearing, only to be then dismissed at the hearing.
Let me stop you and ask you what, you said it was determined by the court that it had merit. How is that determination documented in the record?
And so that's
I'm
where,
not sure that that's actually in the record.
Okay, so that's where
Because appointing counsel and making a determination that it has merit are not the same
all right, so
thing.
there is no order specifically stating it has merit by the trial court. And the way that the trial court was handled under the previous judge, it would be how I would understand that, but I don't know if the record actually says it, meaning when you have a post-conviction, you appoint a counsel, and the state responds that there's an issue for hearing, and then the court sets it for hearing.
No, well,
I'm not disputing that the state clearly filed a response that said, you know, it needed to have an evidentiary hearing.
Correct.
I'm not disagreeing with you on that, but you are arguing that the trial court found that it had merit, and I don't think that's actually correct.
So there is no order in the trial court saying, I also agree that this has merit and should have a hearing. But what I am arguing is that the law is clear that when it doesn't have merit, that the court won't provide appointed counsel. But in addition to that, what I'm arguing is even under the new trial judge that was in place, set it for a hearing. So this matter was set for a hearing after the petition was filed, after the state said it had a hearing was necessary, and then the trial court itself then set it for a hearing.
So you're saying that every time a trial judge appoints an attorney and sets a hearing, that's a conclusion that there's merit to the
Not every time, but what I'm saying in the post-conviction court is when it is set, and the state says, yes, this matter deserves to have a hearing, and then the trial court sets it for a hearing, absent the trial court saying, wait a minute, this I need to enter an order, which the post-conviction court talks about. You get 30 days to either amend this and go forward, and this needs to be fleshed out further. My position is that would have been the appropriate thing if there was an issue.
But that didn't happen.
Huh?
That didn't happen.
Correct.
There was no such order.
That's correct.
Well,
That's the position.
wait a second,
wasn't
though.
an issue.
The court, it's not the court's responsibility to order you to do an amendment. The rule, the actual statute and rule says that after a counsel is appointed, they have 30 days to file an amended petition, or they have to notify the court and say, we're not going to file an amended petition.
Yes.
And after 31 settings, no amendment had been filed. Is that correct?
Correct. It was set for a hearing. It was going to go forward on the petition.
Well, and I've looked at the petition, and you have to agree that the petition is pretty thin on any type of factual basis. It's a lot of legal talk, but there's no, you know, the post-conviction statute requires specificity on claims.
And what I would tell the court, in my position, is that it did have the sufficient specificity. So, for example, it talks about one of the issues was that it asserted that the jury selection method was improper, and it specifically stated that due to the publicity that the case was receiving. When you're saying that based on this publicity, there should have been a request and change in venue because of publicity specifically on this case, it doesn't get more specifically than saying specifically on this case. That's in volume 1, page 10 or page 10 where that petition says that. It also goes on to talk about how the indictments were improperly presented or worded, making them void as far as the charges. That's specific to that case.
Okay, let me ask you this.
Yes.
How is that a ground for post-conviction? Isn't that something that should have been raised on appeal?
But that's what it goes towards, whether or not the trial court was sufficient in raising the grounds or making the arguments to the
That would have been,
judge.
that would have been something that would have been considered previously determined or waived.
And so that's one of the issues. So to go to that point, what I'm saying is, one of the issues that a petitioner is raising on post-conviction is that, because keep in mind, one of the issues he raises is a totality effect or accumulation of all these errors as well. But when you're saying, I had trial counsel who was not effective and he didn't do these things, and as even proof of that, this either trial or appellate counsel didn't even assert this issue or raise that issue, not only does it go to the post-conviction on its own, I believe as a standalone, but it absolutely must go towards an accumulative effect of whether or not the trial counsel or an appellate counsel or both were effective in particular in raising the things necessary.
But again, how does the only petition we have, since no amended petitions were ever filed, I don't see anywhere in that petition any specific facts about the trial alleging how counsel was ineffective. There's a lot of law, there's a lot of boilerplate law in there, but I don't see any specific facts.
See, and I guess what I would say is I disagree when you look at the light most favorably to the petitioner, because it asserts that the trial.
What does the petition say was how trial counsel was ineffective?
Well, it starts off, and again, it says ineffective counsel because it extends.
I know,
to
but
appellate,
you gotta have
it does.
specific facts.
It does, but my position is at the beginning of it and the end of it, the petition starts and ends with, everything I'm telling you is why. To summarize it, the neatly put it in the box, it is alleging all these complaints I'm raising is due to the ineffective assistance of my counsel. So the petition starts that way and ends that way. That's how I read the petition. I believe it clearly, it even has a separate heading that specifically talks about ineffective counsel, but that doesn't negate the fact that it's talking about that throughout, and it's saying all these issues, because you have to keep in mind, it says multiple times, we're talking about the cumulative effect as well. So it's saying, look at these things individually, also look at these things in totality. Specifically, it also alleged that there was issues about the jury instruction on diminished capacity. So it's specifically saying as it relates to diminished capacity as articulated in this case. It's not saying in general that's how that happens. It's talking about it specifically. It also talks about the issue that there were alternate theories of guilt, specifically in this case. I believe that's on volume 1, page 12, where it's talking about how those alternate theories were allowed to be basically presented to the jurors, and that counsel was ineffective for not approaching and directing that. It alleges that the judge didn't do his job as a 13th juror, and again, that's more of a cumulative effect, but that still goes to each and every allegation.
But
and
let's
that's
go to the 13th juror thing. He makes this comment, the judge didn't properly act as 13th juror.
Yes.
But he doesn't explain why. He doesn't explain what the basis for that. I mean, you can say my lawyer was ineffective.
Well,
Okay.
Well-
So what is the factual basis for that allegation? And that seems like he spits out a lot of stuff.
Well-
But as far as factual basis, it's pretty thin.
yeah, based on everything that was alleged, because I believe it also specifically says cumulatively, I believe it uses that very specifically as it relates to the 13th juror, meaning you have to take all of this conduct as a whole. And that's when you would see that if a judge is, essentially what the argument is to me, I would argue is clear, is what the court is saying is that when you see all of these issues happen back to back to back to back, then the trial judge as a 13th juror has an obligation to not confirm the verdict. Now, I understand if you're saying, well, you don't agree, or that's what the argument is.
Is that the
clearly.
basis for a post-conviction? That sounds like something that should have been raised on appeal.
It does sound like it's something that could have been raised on appeal, but I say it's also a basis for post-conviction, because in and of that argument is the fact that you have counsel not making these arguments for you on your behalf.
Isn't this why you have to file an amendment?
I'm sorry?
Isn't this why amendments should be filed?
Well, there's times where amendments are filed and times are not, and that's why, I think that's why you have a hearing to determine if the proof is now substantiated, because the allegations in the light most favored to the appellant makes out allegations, and now you need a hearing to determine, is there any substance to it, especially when the state is saying, yeah, there's substance to it. Let's go ahead and have a hearing. Again, it also talks about a failure to adequately present witnesses, and it says that he specifically requested to his trial counsel. Those different things are raised, but in addition to that, when the court enters its order, all the concerns that are being raised now and even argued by opposing counsel was never said by the trial court. The trial court said that it said that, quote, you'll get a written order and it's going to list every single date. It's going to list every single issue raised and how I not only don't see a colorable claim, which is what we're all questioning, but counsel did not amend the petition as required by statute. That's volume 2, page 7, lines 15 to 19. So this is the trial court judge saying, look, I'm gonna take each issue and I'm gonna tell you, this is why it didn't apply, this is why this wasn't clear, this is why there's an issue. We then get an order that we all can see. It does none of that. It never took these issues one by one. It never said that. This is the trial court asserting affirmatively, this is what I'm gonna do. I'm about to clean this up and clarify where you went wrong and why. They do none of that. Their order doesn't stand by the words they said out loud, and they simply is looking to this court, quite frankly, to clean it up. And that's not fair to the appellant who was ready, willing, and able to have a hearing. The reason the hearing didn't go forward, as the record is clear, the state was not ready to say to the appellant, well, this has been reset multiple times. That is not a sufficient argument when the appellant is not the reason for the delay, and when the court is asserting as if it's going to enter an order, explaining how the appellant was the reason, and then never does that.
Well, so it looks like that there were multiple
There were
continuances.
There were.
I can't really tell what in the record is going to show us why all of those continuances, who requested them, and what was going on there.
That's the issue. And again, I wasn't on it the whole time, but from what I represent to the court in the transcript is, if you look at those continuances, you'll see that the defendant was ready and the state had multiple turnover with multiple different attorneys.
So you're saying the record's going to show that the state requested most of these continuances?
Yes, the defendant was not sitting there just requesting continuance after continuance. And again, what we further asserted to the court, which again we thought would be in the order, is if you're saying otherwise, because the court said we're going to pull it, then just tell us that this is what we did. Because even if you if you had nothing else as a record, you have on May 19th the state acknowledging we are the ones not ready today. That's the day of the hearing, and at a bare minimum, that's the date that they're not ready. If you don't know any other date, we know on May 19th, 2023, the state wasn't ready. The state has informed the court of that, and then it was dismissed for lack of prosecution. In addition to that, I think it's telling that, as has been discussed earlier, there's tremendous issues as to what day this order was ever even entered. I don't believe it's even a real dispute if we take trial court at its word that there was no order that existed on May 19, 2023. The documents attached to the notice of appeal made it clear, as late back as on May 19th, around that time, it was clear, that showed that there was no order entered. And then sometime later in the month of June, I believe it was June 21st, 2023, you can go back and look at the same history, and then it shows order entered, dated May 19th, 2023. Not only did that order not exist in as far as that appellant had access to it, but even when the appeal was filed, appellant never saw the order. The appeal was filed without it. And I think that's very concerning that you have something clearly dated May 19th, especially when we're dealing with issues about a dismissal on the date of a hearing where the trial court is saying, I'm going to spell out exactly why I did it, and then doesn't do it. Says, I'm going to show why it was a lack of prosecution on the appellant, and then doesn't do it. And when you have those concerns, and then there's genuine questions about when the order was entered, so much so that opposing counsel moved to dismiss this appeal for not being timely done, that is extremely problematic. And I appreciate what the court is here for, to oversee a matter, and if this matter is not remanded so that the public can have some level of comfort about what has occurred on this case, I submit that I think this would be very troubling, because again, if we didn't have the documentation to show that there was no order entry on May 19th or anything else, and then we just file appeals sometime in July, I believe, July 20th, 2023, it looks a whole lot like, oh, that either defense counsel or the defendant was just asleep at the wheel and made a mistake, overlooked it. That's a very plausible thing to believe. No one likes to get into these exchanges where you're asking that the trial court be recused or having to do these things, but it looks very bad, like maybe it was just an oversight, and it would have been hard for anyone, and I'm saying from the outside looking in, to believe, no, that order wasn't there. It looks a lot like we just would have overlooked it, but then you have transcripts where the court is acknowledging in the court's own words that nothing in those transcripts can be purported to mean that on May 19, 2023, this order was entered and filed. And when you have an order clearly not just stamped, but typed in the date, May 19, 2023, so that's typed in by the trial court. And then it's stamped by, I don't know who stamped it, but there's no question the order's by the trial court signed. And we know that that date is not correct, and it has issues about the way the order was entered.
How do we know the date wasn't correct?
Well, because the trial court, we have to take their word on it when they said that the earliest they would get it done is within judicial conference, which was not May 19th. And we have to take the trial court's word on May 19th when they said, I won't have it. It'll need to be at least a few weeks. So we know it because we are trusting the trial court. And the representations the trial court made is how we know that that date isn't correct. Because the trial court then, in a different transcript, as late as June, acknowledged that it was not entered on May 19th, which was also included in the motion. My response to their motion to dismiss, it highlights that. It's also referenced in the Terrence Holiday case that's later, where that transcript was taken from. The trial court is clearly acknowledging it wasn't done that day. And so the other point I believe the argument opposing counsel makes is, well, hey, if you're making a recusal motion, it needs to be in writing, and you can't just kind of raise it now. Keep in mind, we didn't know this was going to be an issue until these issues happened. When we got this order and the time we got it, we couldn't predict the future. So that's why it didn't exist until we had that affirmative information.
Well, okay, you've run out of time.
Thank you.
All right, thank you. Good morning again to you, General Douglas.
Good morning again, Your Honors. Davey Douglas on behalf of the state. And this court should affirm the dismissal of the post-conviction petition here because it simply failed to state a colorable claim for relief. And before we get into that, though, I would like to address the issue of the timeliness or the date that the court dismissed the petition. There's been a suggestion that that date is wrong, that there's a dispute about it, and that is simply incorrect. This court has resolved any issue about the date that order was entered when it deemed the petitioner's notice of appeal untimely. The order is file stamped by the trial court clerk May 19th, 2024. And when the state filed a motion to dismiss, this court ordered the supplementation of the record with the minutes of the trial court. And when those did not have any entries on the date of May 19th, all we had to go with was the file stamp date on the judgment, which is May 19th. And so this court therefore deemed the notice of appeal, which was filed in July, untimely. So this court necessarily concluded that the order was issued on the date that it's file stamped. So there's nothing nefarious about the date of the order. And as Your Honors are all very familiar with, trial court judges, when they say one thing about when they might issue an order, that doesn't bind them to it. They can get it done quicker, which is what happened
The other way
here.
around, but I guess it can happen quicker.
But that's what happened here. The trial court sort of gave an estimation about when it might have an order, and then it got it done quicker. And in entering that order, the trial court properly determined that the post-conviction petition here simply failed to state a colorable claim.
Let me ask you a question, because this is the defendant or the appellant's position, that once the judge appoints counsel and it's set for hearing, then the court can't summarily dismiss it because the court somehow has already made a finding that there's a colorable claim, and therefore he's entitled to a hearing.
Yes, Your Honor, and the state would respectfully disagree with that position because the statute bears out that a post-conviction court can dismiss a petition after appointing counsel, and that's what our Supreme Court concluded in Burnett versus State. Burnett is really procedurally similar to this case in that the post-conviction court initially entered an order appointing counsel. Counsel did not file an amended petition, and the post-conviction court then summarily dismissed the petition. That's exactly what happened here. And Judge Ayers, as you were asking about, nothing in the court's order appointing counsel said that the court found that the petition was meritorious or that it stated a colorable claim. It simply appointed counsel here. And appointing counsel and setting a case for a hearing by itself is not a ruling or a finding from the court that the petition has merit. It's simply moving along in the process, and then the court properly evaluating the petition and determining that it didn't state a colorable claim, which is what the court did here. And as has sort of been alluded to and asked in the questions, there's a lot of boilerplate language in this petition, a lot of sort of standards of review and other legal citations, but there's no factual support for any of the claims. And it's not sufficient simply just to say that counsel was ineffective or counsel failed to investigate. The failure to investigate was a claim that this court concluded was not colorable in both Pewitt versus State and Calhoun versus State. You got to do a little bit more. You have to explain what counsel should have investigated, or you have to explain what counsel failed to identify, what a further investigation would have yielded. We simply don't have that here. We just have conclusory allegations that counsel was ineffective. And with both our Supreme Court and this court have repeatedly stated is that's not a colorable claim for relief and that it's appropriate for summary dismissal.
Does it matter that the state filed a response saying we need an evidentiary hearing? Again, that looked like a boilerplate order, but or response, but what's your thought on that?
I would agree with you. It did look like just sort of a boilerplate response. It didn't look like it was specifically addressing.
Does it matter, though? that
But
they
it
said
doesn't.
We want an evidentiary hearing?
It doesn't matter, Your Honor, because the state is not the one who adjudicates the petition. That's ultimately the role of the court. And again, that's something where the state can, at first glance, say, okay, a hearing's warranted here, and then they're not bound by that. That doesn't bind the post-conviction court. The post-conviction court still has to look at the petition, and it's well within the court's discretion to, at that point, even after appointing counsel or having set it for a hearing, conclude that there's just not a colorable claim for relief. And that's what the post-conviction court properly did here.
Does the record help in any way about why it was continued so many times? And do you agree that it was the state requesting those continuances?
I do not agree that it was the state requesting those continuances. The record is sort of silent as to why. We've got two notations that it was continued due to COVID, but the court.
Well, let me ask you this, because the day we're talking about, May 19, or whatever the day was when we have this, the end of the whole thing, there appears to be a problem with a witness. It was the attorney that represented the defendant was not available. And then the state made some comment that there was a transcript of something that had to be provided to the defendant. So it didn't seem like anybody was ready for hearing on that day. At least that's what it appeared like reading the transcript. So, this wasn't a situation that I could tell where the state was saying we're ready to go. It was like neither side was ready to go, it appeared like.
I think that's a fair characterization, that neither side was ready to go. And I think what had sort of irritated the post-conviction court is that both parties had said at a March date that they were ready to go, and it was the state who was unable to track down trial counsel that day. But I think it was the defendant who had said there was still a transcript that he needed that he hadn't received. But at this point, the case has been set for over 3 years. So the petitioner is certainly playing a role in the continuances here and the setting off of the case. But when the court listed all of the dates that it had been set off, it didn't specifically attribute to either the petitioner or the state. But I think it's a very fair inference for the post-conviction court to draw that the petitioner here was at least responsible for some of those delays, particularly since there had been no amended petition or notice that no amended petition would be filed here. And then turning to, I feel like there was sort of some discussion about the recusal issue for the post-conviction court. The state would first submit that that issue has been waived because there was no motion made, and even if there's an argument that this is a case that the court should have sua sponte recused itself, that argument's not supported by any citation to authority in the briefs. But even if the issue is not waived, the post-conviction court here was not required to recuse itself. There's nothing in the post-conviction court's statements and written orders that would rise to the level of allowing a reasonable person to question the court's impartiality.
Rule 10B requires a written motion with an affidavit, I believe. Is that correct?
Yes, Your Honor.
And without that, the court can summarily dismiss. Because there's nothing written, where exactly did this motion come up? Because reading the record that we have, the transcript ends with, I'm going to enter an order, and that's the end of it. I mean, there's nothing in this particular record that deals with the recusal.
The first time the recusal really came up, I think, was in the briefing in this court. There was not a written motion filed to recuse. There was not a request made at the hearing when the post-conviction court announced it was going to dismiss the petition. So the first time we really are getting to this recusal issue is on appeal, which is one of the reasons why the state is arguing that the petitioners waived the issue. But again, even if it's not waived, the post-conviction court was not acting in a partial manner towards the petitioner. It reasonably examined the petition and the claims that the petition included. The court also took time to list out each of the general allegations that the petitioner made. So this wasn't just the court paying lip service. The court thoroughly examined the petition, and while it didn't necessarily list each individual sub-allegation out, its order demonstrates that it considered the petition and that it properly concluded it failed to state a colorable claim for relief. And there's just, again, nothing about the court's comments or anything in its written order that would show that it lacked the ability to remain impartial. And because the court properly dismissed the petition for failure to state a colorable claim and was not required to recuse itself, we would ask this court to affirm the judgments of the post-conviction court. Thank you.
Thank you, General Douglas. Mr. Tootin, you've got some rebuttal time, I think.
Yes. And just to clarify, the transcript that was being referred to on May 19th was a transcript the state didn't have. The appellant was ready to go forward. The appellant was not asking for a delay. In fact, the appellant was ready to go forward even if trial counsel was not there. So the transcript will reflect from May 19, 2023, it was not the defendant who was not ready to go forward.
Mr.
But-
Chu, let me
yes.
just, and again, I read the transcript, and obviously the person that was representing the defendant was not you. It was
Correct.
somebody apparently was there for
From
you.
my office, yes.
Okay. So, and she did not indicate that apparently she was down for the reset too. She didn't get up there and say, we're ready for a hearing.
No, we knew before in that was going, we didn't oppose it. We made it clear, and that's why. But typically, if it's the defendant, we have to start the conversation and fall on the sword. But that's why you see in the transcript, the state basically takes that conversation over, and we weren't going to fight them on it. So yeah, we understood that they were not going to be ready to go, and we were not. Now, again, if we knew that it was going to be dismissed, we would have obviously not done the state a favor to the detriment of the defendant. But going back to this record, when I was referring to the issue about it being heard on May 19th, and the recusal issue was raised here for the first time, because after the court denies it, obviously there is nothing to ask the judge to recuse on because it's lost jurisdiction. But specifically, the court had stated, because I had promised Ms. Jones, the other attorney, I'd have it done around judicial conference. And when I had it done around judicial conference, I didn't have a clerk available. So this is cited too in my motion, the response to the motion to dismiss, but it's also part of the briefing in the Terrence Holliday case. It is clear the order did not exist on May 19th, or at a minimum, it was not filed and entered through the trial court's own words. There's no representation of the trial court said, no, I did it May 19th, 2023, and I
What
submitted
you
it.
just read to us was from a different case, right?
But it was regarding that issue. And that's why I was cited to, and it's in the response to the motion to dismiss.
But it's not in this record.
It is. It's in the response. Yes.
That's in your response.
Yes,
not
and it
actually
cites
the
to the.
record. But it's
it's taken
technical record is
judicial
not-
notice of another matter. That transcript is already before the court. So what I'm saying is, although it's very clear that order didn't exist. And so again, when the judge, the trial court itself is the one saying these deficiencies are happening, and the trial court itself has put this order dated this manner that causes these concerns, you have to question whether this was done correctly.
Let me
especially-
stop you for a second before you run out of time, because we need to get this, okay. May 19,
2000
judge dismisses it.
Yes,
And you're saying, well, we couldn't file the motion to recuse until the briefing because the judge lost jurisdiction. Judge doesn't lose jurisdiction for 30 days.
Okay.
You could have gone in immediately and filed a motion, so the judge had an opportunity to respond to it. The first time we're seeing it is on appeal.
correct.
And the judge never had a chance to actually answer these questions.
And it's in our position, we didn't have a chance to answer it either, because our position is our petition. I know it was alleged to be somewhat deficient. I would take our petition and compare it to the judge's order, and the petition is a lot more detailed than the judge's
But I'm
order
still
against
talking
it.
about the recusal.
Yes.
I mean, you could have filed your recusal while, for 30 days, you had an opportunity to file recusal and say the judge should have recused herself.
Well, again, that comes down to a question. We never even seen the order at that point. We didn't know if the judge was actually going to stand by what she said or did.
But then,
And-
but you supposedly had a reason for recusal. You should have filed something.
Well, we never got the order, which goes to my point, which is why I ended up having to file the notice of appeal, making a clear representation to the court. I'm filing this notice, and I haven't even seen the order. I didn't know if the judge was going to back down, because I thought once it came time to putting that in writing, it would be very difficult for the trial court to stand behind it. So I would have loved to have seen the order and see if the order, and give me 30 days from the order. But after it got to July, I've never seen the order. I just had to file an appeal and note it on the notice. I haven't even seen the order, but I'm filing the appeal anyway.
Mr. Tuden, a couple of quick things. I appreciate your zealous
Oh, yeah.
advocacy for your client. And I don't mean to state the obvious here, but basically, we're here to correct errors that happened at the trial court level. So I think what the point Judge Campbell's making, and maybe I don't need to try to remake it for him.
Okay.
I don't think I do, but unless we have something that happened at the trial court level to correct, because it was the wrong thing that happened, we don't, that's why you say, well, you first bring it up on appeal.
Correct.
And
again, and that's.
we can't correct something
No,
that
no.
we don't know what even happened.
And just that request in the brief, when you see it, is basically saying, when this case is reversed and remanded, which I'm hoping that is the case, please at that point consider recusal. But the fact pattern of what happened is to say, when this case was dismissed on May 19, 2023, the way it was, you have to look at this other conduct to show that supports why it shouldn't have been dismissed. And then separate and apart from that, if and when this is remanded, can you, because I know the court does have the authority to say we're remanding it and assigning it to someone else. That's what the point of that request is for the first time here, is to say, we're just saying if it gets remanded, let's let that all be water under the bridge and let's just send it to somewhere else. So, but the facts alleged is just to show why I disagree that May 19, 2023 was
My
appropriate.
second point, which is not repetitive of
Okay.
Judge Campbell's, if the fact that a judge rules against you like this judge did.
Yes, it happens a lot, so it's no.
That is not by itself
Correct.
grounds for recusal.
Correct.
So I sort of got the idea that you didn't know you needed to file for a recusal until you found out your case had been dismissed. And
No.
that's not how it's supposed to work.
Correct, no, and that's not what I'm saying. What I'm
Okay.
saying is, there was no need to file a recusal in the trial court level until we actually seen what was going to be filed, and before I knew it, I had to file a notice of appeal. But the facts relating to that is to say why the May 19, 2023 was not appropriate for the judge to do it. That was just further support to say, this doesn't look good, and this doesn't look appropriate, and it at least gives an appearance of impropriety.
All right. Thank you.
Thank you.
All right, we'll take about a 10-minute recess. I think we've got 2 more this morning.
Yeah, I know. Guess we just keep tagging out. That's right. You're like wrestling, like tag. You're in the hand.